Hello and welcome. I am Professor Rashmi Raman and this is Module 15, Crimes Against Humanity, Part 1. Learning Outcomes. In this module, you will study the origin and the meaning of crimes against humanity. You will learn about the various definitions of crimes against humanity given under the ICC, ICTY, and ICTR statutes. You will learn about the objective elements which are required in order to establish crimes against humanity under the three different statutes. Let us begin with an introduction to crimes against humanity under general international law. Crimes against humanity cover a common set of factors. They are particularly horrible offenses as they are considered grave attacks on human dignity or grave humiliation of the victims. An individual or an isolated attack cannot be considered as a crime against humanity. It is only when the attack becomes widespread and organized in nature that it can be either carried out through laws or practiced, tolerated, and condoned by the government or any other effective authority. There is no requirement that the attacks have to be committed during an armed conflict under any statute or customary international law. Irrespective of when the acts are committed, international law requires a blanket prohibition against them. Under customary international law, the victims of the crime can be either civilians or, when crimes are being committed during armed conflict, persons who do not take part or are no longer involved in armed hostilities or enemy combatants. However, under the statutes of the ICC, ICTY, and ICTR, crimes against humanity can only be committed against civilians, whereas customary international law holds a broader notion that it can be committed against anyone. The notion of crimes against humanity was first formulated in 1915 on the occasion of the mass killings of the Armenians by Turkey within the Ottoman Empire. This led to a strong reaction from the French, British, and Russian governments, which prompted them to jointly issue a declaration to personally hold liable all members of the Ottoman government and their agents who were implicated in what came to be known as the Armenian genocide. However, this failed as there was a lack of practical follow-up to the joint protest, and it only intended to solve a short-term political problem. One more attempt was made after the First World War, where a special commission was set up which reported to the Versailles Conference that an international criminal tribunal would be created whose jurisdiction would extend to offenses against humanity, as this crime was then called. However, this idea was rejected by delegates from the United States on the basis that the laws and principles of humanity were not certain and varied with time, place, circumstance, and sovereign. Moreover, the US opposed it because there was no fixed and universal standard of humanity, and because a judge might interpret it according to his conscience or beliefs. As a result of this very valid opposition, no provision was drafted for crimes against humanity. Thirdly, a key attempt was made in 1919, where a few extraordinary court-martials were established in the Ottoman Empire to prosecute the perpetrators most responsible for the 1915-16 deportation, massacre, and looting of Armenia. The Allies during the Second World War became aware that barbarous acts being committed by the Germans were not prohibited by international law. The Germans had committed atrocities not only against their own citizens, especially the Jews, on political and racial lines which were not covered by the laws of warfare, but also against civilians from other states, such as Poland. Moreover, in 1945, persecution for political or racial purposes was not prohibited, even if it was being perpetrated against civilians of occupied territories. However, after the Second World War, in 1945, the London Agreement was formulated, which embodied the Charter of the International Military Tribunal, under which a provision was included that gave the tribunal powers to prosecute and punish persons guilty of crimes against humanity. The Nuremberg Charter treated crimes against humanity as a separate offense. Article 6, Clause C of the Nuremberg Charter defined crimes against humanity as follows. Crimes against humanity, namely murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic laws of the country were perpetrated. One of the major shortcomings of this definition was that it linked crimes against humanity to crimes committed during armed conflict. Moreover, this was not legislated keeping in mind the consequences or implications it could have had on third states. If an inhuman act was committed within a national territory, it would be considered as the exclusionary concern of the state and would fall within its domestic jurisdiction. On the 11th of December 1946, the General Assembly of the United Nations adopted a resolution which, accepting the principles of the Charter of the Nuremberg International Tribunal and its own judgment, gave a new definition. Similarly, it again passed Resolution 3.1 of 1946 with a recommendation for the extradition and punishment of persons accused for crimes provided for in the Charter. As a result, crimes against humanity were being recognized as a violation of customary international law and also a jus cogens violation. Subsequently, in the same year, the Crimes Against Humanity provision of the Control Council Law No. 10 was mentioned in similar terms, but extended the list of offences to include other wrongs such as imprisonment, torture, and importantly, rape. The CCL No. 10 did not limit crimes against humanity to armed conflict and expressed that crimes against humanity were offences which could be committed during times of war as well as times of peace. Over time, therefore, the link between crimes against humanity and the presence of an armed conflict was blurred to the point of extinction. What are the extant definitions of crimes against humanity under the three statutes of the ICC, ICTR, and ICTY? The tribunals have a great influence on the interpretation of the law of crimes, especially crimes against humanity, and have converted abstract concepts into full-fledged and well-defined law. Article 5 of the ICTY statute defines crimes against humanity as follows. The International Tribunal shall have the power to prosecute persons responsible for the following crimes when committed in armed conflict, whether international or internal in character, and directed against any civilian population. And the list of those crimes are murder, extermination, enslavement, deportation, imprisonment, torture, rape, persecutions on political, racial, and religious grounds, other inhumane acts. The essential ingredients which are common to both the above statutes are that the perpetrator should have caused serious mental or physical suffering in the victim or victims. That act must be systematic and widespread in nature. It should be discriminatory in nature under the ICTR but not under the ICTY. The perpetrator must possess knowledge of the crime and must have the intention to commit such a crime, and that the definition of crimes against humanity is given in Article 7(1)(a) of the Rome Statute. That has elements from both the two other statutes. The Rome Statute says that for the purpose of this statute, crimes against humanity means any of the following acts when they are committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. And the crimes listed under the Rome Statute are murder, extermination, enslavement, deportation, imprisonment, forcible transfer of civilian population, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. Persecution against any identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, or gender grounds as defined in paragraph 3, or other grounds that are universally recognized as impermissible under international law. In connection with any act referred to in this paragraph or any crime within the jurisdiction of this court. The Rome Statute also includes enforced disappearance of persons as a crime against humanity. One can see that Rome Statute has enumerated the crime of apartheid as a specific crime under J just before it lists other inhumane acts of a similar character intentionally causing great suffering or serious injury to body or to mind or physical health. The Rome Statute therefore extends the category of offences set out in the ICTY and the ICTR statutes, and the ICC list now includes enforced disappearances of person, apartheid, sexual slavery, forced pregnancy, and sterilization. Further, the grounds for persecution extend to national, ethnic, cultural, gender, and other grounds which have universal recognition. The meaning of committed in the course of armed conflict. Customary international law does not envisage the requirement of armed conflict in order to establish that a crime against humanity might have taken place. Therefore, crimes against humanity can also be committed during peacetime. However, under Article 5 of the ICTY, it is a fundamental prerequisite. It is not a requirement under the ICC and ICTR statutes. Armed conflict is known to exist between states or groups within the state or government authorities or organized armed forces when they resort to the use of force amongst themselves. In the Tadic case, through its interpretation of the words committed in armed conflict under Article 5 of the ICTR statute, the Chamber showed that it was necessary for an armed conflict to exist at the relevant time and place, and that the offences had to be committed only during this armed conflict. Moreover, the Tadich chamber also held that the armed conflict requirement was a jurisdictional requirement, but not a mens rea requirement. The mens rea of the perpetrator did not necessarily have to encompass the armed conflict itself. What is the meaning of an attack within the definition of crimes against humanity? The trial chamber in Kunarak defined an attack to mean a course of conduct which involved the commission of acts of violence. Elements required for an attack were stated in Kunarak as follows. There must be an attack. The perpetrator should be part of that attack. The attack must be directed against a civilian population. The attack must be widespread and systematic. And the perpetrator must know the wider context in which his acts occur and know that his acts are part of a wider attack. Similarly, an attack is also defined in the statute itself. Article 7.2a of the Rome Statute defines attack as a course of conduct including multiple commissions of acts against any civilian population in furtherance of a state or organizational policy to commit such an attack. How does one define course of conduct? Course of conduct suggests that the attack must be carried out over a period of time and cannot be an isolated act or a random act carried out on the spur of the moment. Limaj et al., the trial chamber decision of November 2005 of the ICC tells us that to amount to an attack, the relevant conduct need not amount to a military assault or a forceful takeover. The Galich case, the trial chamber of 2003 says, in the context of a crime against humanity, the word attack is not limited to armed combat. It may also encompass situations of mistreatment of persons taking no active part in hostilities, such as of a person in detention. A widespread or systematic act committed against any civilian or a civilian population can even constitute a single attack upon an individual. Further, it does not have to be an act of physical violence. It can also be a non-violent conduct, such as the policies of internment, apartheid, deportation, or discrimination, which need not include violence. Attacks can either be authorized by the state or be part of an organizational policy of an organization which needn't necessarily be attached to the state but must have the authority of the state. For example, acts committed by an ordinary businessman, medical and training personnel will also fall within this ambit. Finally, let's look at the meaning of the most controversial term, widespread or systematic. In order to establish crimes against humanity, under the ICC, ICTY and ICTR, it is not mandatory to destroy any groups. However, it is necessary to establish widespread and systematic violations. The words widespread and systematic are an essential requirement when prosecuting someone for crimes against humanity under the three statutes, ICC, ICTR and ICTY. Of these two terms, widespread refers to acts which are massive and large scale in nature, that take place frequently with considerable seriousness against a multiplicity of victims. The offense can be committed even against a single individual, provided that that individual should be part of the civilian population. Factors which have to be looked into for assessing whether an attack is widespread or not are the numerical size of the group, the area in which the population lives, and the grave consequences which result from such an attack. However, the word systematic refers to the actual planning, preparation, strategy, and the strategy to execute an attack. In the case of prosecutor versus Blaskich, it was held that systematic can mean a political objective, a plan initiated before the attack is executed, or an ideology to destroy or weaken a community. Basically, it requires the establishment of a methodical plan. It is not necessary to prove both widespread and systematic nature of an attack. It is sufficient to prove one factor, which can be either widespread or systematic. However, under customary international law, it is not necessary to show an existing plan or policy to execute an attack which constitutes a crime against humanity. This becomes a very important distinction between customary international law and treaty law. It is also important to note that it is not the act of the accused, but the attack as a whole that has to be widespread and systematic, as held in the case of prosecutor versus Miroslav Deronyik. We now come to the meaning of any civilian population. There needs to be a distinction between the targeting of armed forces involved in a conflict and the civilian population who are caught in such a conflict. According to Article 48 of Additional Protocol 1, 1997, it is important to make a distinction between military and civilian objects even while carrying out military objectives. Article 57 of this protocol also defines the importance to be given to civilians. It requires the parties to the conflict to take protective measures against attack on civilians and civilian objects. Article 5 of the Statute of the ICTY refers to crimes committed against civilian populations irrespective of their race, nationality, religion, or political status, and is non-discriminatory in nature. However, Article 3 of the ICTR statute refers to attacks against a civilian population and says that they need to be based on national, political, ethnic, racial, or religious grounds, and therefore discriminatory in nature. Civilians include not only non-combatants, but also persons who are no longer involved in hostilities. That is, members who were at one time involved in an armed resistance movement but now have either laid down their arms or have stopped such conduct. In the Blaskich case, the trial chamber concluded that the head of a family who tries to protect his family by having a gun in his hand does not lose his status as a civilian. This was said to apply to even a sole policeman or local security guard doing the same thing. The word civilian therefore has a wider connotation, and even when a few members of an armed group are intermingled with the targeted civilian population and then the whole group is attacked, that group is still considered to be civilian as it is predominantly civilian. This Blaskich judgment also pointed out that the commentary on the additional protocol by the International Commission of the Red Cross, that the following persons are to be excluded from the definition of the word civilian status, is to be considered. Who are excluded? 1. Members of the armed forces of a party to the conflict, as well as members of militia or volunteer corps forming parts of such armed forces. 2. Members of other militia and members of other volunteer corps, including those of organized resistance groups, movements, those belonging to the parties to the conflict and operating on, in or outside their own territory, even if this territory is occupied, provided that such militia or volunteer corps, including such organized resistance movements, fulfill the following conditions. That is, that of being commanded by a person responsible for his subordinates, and that of having a fixed, distinctive sign recognizable from a distance, and that of carrying arms openly, that of conducting their operations in accordance with the laws and customs of war. Further, members of regular armed forces are excluded who profess allegiance to a government or an authority not recognized by the detaining power or by the powers that are in conflict. Other excluded categories are inhabitants of a non occupied territory who, on the approach of the enemy, spontaneously take up arms to resist the invading forces without having had the time to form themselves into regular armed units, provided that they carry these arms openly and that they respect the laws and customs of war. Thank you.